This is an appeal in the matter of Borges and the Secretary of State for the Home Department.
Yes, good morning, Mr. Malik.
Good morning, my lord.
Have you had a chance to discuss how you're going to divide the day up?
Yes. It seems very likely that we will finish by lunch. Now I propose to take no more than an hour and 15 minutes. Miller and Trent will take an hour or so, and then 15 minutes of reply.
Good. Well done. We've read everything I think that we need to read. Thank you very much for your documents. Is there any preliminary issue we need to resolve? There's a respondent's notice, isn't there? Do we need to make a decision about that?
There is no objection to it.
Okay. Right. Well, we'll take it in your stride, Mr. Malik. We'll get there in a moment.
And I wonder if you have seen my supplementary skeleton.
Thank you for that. Okay. And we referred you, or ladies referred you to a couple of cases, which no doubt you're going to have a look at as well in due course. Okay, thank you very much. One thing which surprised me was the point on ground one hadn't arisen before.
No, there's no authority on that particular point.
I mean, it seems like the sort of point which probably has arisen, but there's no case on it.
No.
Is it an unusual fact pattern?
Yes, I'm not entirely sure.
Mr. Carrick's nodding.
Well, it's very rare for someone to acquire union citizenship, as it were, partway through.
Well, maybe it is. Then it struck me as though it might not be very rare, but obviously it is.
Yes.
Well, cases are always throwing up unexpected legal points.
Yeah.
As Milady and I know from another jurisdiction a week or so ago. Anyway, right, Mr. Malik, where do we start?
Yeah, so, ladies and lords, as you know, I appear for the Secretary of State this morning, who is the appellant. But then friend Mr. Karim appears for the respondent, Mr. Borges, with Mr. West. So, my lady and lords know from the papers that Mr. Borges is a citizen of Portugal, and the Secretary of State seeks to deport him to that country in the light of his criminal conduct. He was previously a citizen of India and came to this country in 2002 as a family member of his father, a Portuguese national exercising treaty rights. He committed crimes relating to driving and stolen goods in 2008 and received a sentence of 30 weeks in custody.
2008.
Yes. He was warned by the Secretary of State that he could be deported if he committed further crimes.
Yeah.
He committed more crimes, namely robbery, and received a sentence of 21 months in custody in 2011. The Secretary of State sought to deport him in 2011, but the First Tier Tribunal held that his deportation would be a breach of the treaty rights and thereby unlawful. So the Secretary of State ended up giving him another warning that he could be deported if he committed further crimes. That was in 2012. He did two things thereafter. First, in 2014, he surrendered his Indian nationality and obtained a Portuguese passport. And second, he committed further crime, for which he received a sentence of 6 years in custody in 2019. The Secretary of State made another deportation decision.
Sorry, I should know the date, but yeah, he was sentenced in 2019.
Yes.
The way you described it was that two things occurred in 2014. You said he changed his nationality and he committed the offences. Is that right?
No, my apologies. So what I thought what I meant to say, and I thought what I said was that two things happened thereafter. So after 2014.
All right. Do we need to know when the offence was, or we probably don't? In 2019, he was sentenced.
Yes. You have a sort of detailed factual background in my skeleton argument that the date, if it assists, is 3rd of June 2019.
That's the date of sentence.
That is the date of conviction.
Conviction or sentence, but when was the date of the offence?
3rd of May 2019.
Very grateful.
The judge's sentencing remarks are quoted at some length in the decision letter, page 170.
So it's all 2019. The whole thing, the criminal offending relevant matter, all days 2019. At which point he'd been in EEA national for 5 years.
Yes. But of course, the other fundamental point is that the last offence was committed before the UK's exit from the European Union.
Right.
And that is the reason this regime applies to him.
Yeah, but all I was trying to get through is that there was you may not have intended to suggest this, but you're not at the moment suggesting that the surrender of the Indian nationality and the obtaining of the Portuguese nationality was with a view to continuing to commit crime to avoid deportation. I think that's sort of
my fault. I
It crossed my lord's mind and my mind independently. That there was some sort of
Didn't
connection.
cross mine.
Didn't cross my ladies.
some of us are just old cynics.
We're more suspicious than my ladies. Anyway, so that, but the fact is, 2014, the change of nationality, 2019, all this, the third set of offending, and he's sent to prison.
But just before we go on, I mean, the decision letter appears to suggest, and this isn't, I don't think, mentioned by the First Tier Tribunal, that he was sentenced to a sentence of 30 weeks imprisonment in 2008.
Yes.
Paragraph 16 of the decision letter.
Yes, so that was the first
offence
conviction.
he mentioned.
Yeah.
So does that appear in the where you say it's not in the FTT?
Well, I hadn't seen a reference to it in the decision letter. Maybe I've
Decision
not
letter.
read it carefully enough. Yes, because in paragraph 4 of the FTT decision, it says full offending set out at 16 to 19 refusal. His first period of imprisonment was between February the 11th and March 2012 for 2 counts of robbery. So in other words, the FTT has ignored the first sentence of imprisonment.
That's right. Yes.
Yeah.
Okay.
So following his latest conviction, the Secretary of State issued another deportation decision. This is the second deportation decision that the Secretary of State has issued, and these proceedings arise from that decision. The First Tier Tribunal has held that Mr. Borges enjoys highest level of protection against deportation because he has resided in the UK for a continuous period of 10 years for the purpose of Regulation 27(4) of the 2016 regulations. And therefore, the First Tier Tribunal held that his deportation could only be justified on imperative grounds of public security. The First Tier Tribunal also held that there were no such imperative grounds in the case, and the Upper Tribunal has upheld the First Tier Tribunal's decision. Now, I shall seek to persuade you, my lady and my lords, that the decisions made below are wrong in law on 2 separate grounds. The first ground, as lady and my lords know, raises a question as to the proper construction of Regulation 27(4). My case is that the tribunals misconstrued that provision in holding that Mr. Borges enjoys highest level of protection against deportation. On proper construction of that provision, he only enjoys middle tier protection. The second and the alternative ground is that the First Tier Tribunal, in any event, had erred in law in holding that there were no imperative grounds of public security justifying the deportation. And therefore, it was not open to the Upper Tribunal to uphold that decision. subject to any observations, what I propose to do is to address you on the two grounds in turn. And in doing so, I shall seek to assist you in relation to the point that my learned friend has made in the respondent's notice. So dealing first with ground one, construction of Regulation 27.4, the court knows that there is no authority on the subject. So what I will therefore do is to take you first to the directive and make submissions about it. I will then take you to the regulations and seek to assist you in relation to the provisions there. I will then deal with the reasons given by the Upper Tribunal for dismissing the Secretary of State's appeal, and finally I'll deal with the point that is made by my learned friend against me. So the directive, the Citizens' Rights Directive, is behind tab 1 of the authorities bundle. And can I show you first chapter 3 of the directive, which you have at page 9 of the bundle.
Is there anything in the recitals? Yeah.
No, not that isn't obvious from the actual articles.
Well, even so, if it's just doubling up, what is there in the recitals that might conceivably be relevant, if anything? Sorry.
Yes, so the recitals, page 2, 3, and 4.
Yeah.
Recital 5 is about the right of Union citizens to move and reside freely within the territory of the member states.
Yes.
And that right is subject to certain conditions and also extends to family members irrespective of nationality. And there is a definition, recital 5 says, as to the phrase family members. Recital 9 is about the right of entry and residence for the first 3 months. And recital 12 is about residence more than 3 months.
So recital 9 refers to union citizens, and recital 11 says that the fundamental and personal right of residence in the United States conferred directly on union citizens by the treaty. Is that important?
Yes, I'm not sure if it assists anyone in the case, but Milady is right to point that out. That right is automatic and is not dependent on any administrative procedures. Recital 13 concerns the residence card requirement in relation to family members of union citizens who are not nationals of a member state. So in other words, there can be no residence card requirement for a union citizen. Finally, recital 22.
What about 17?
lady, my lord, that recital is about permanent residents choose to settle after long terms in host member state, and you'll see the purpose. And look at the second sentence of recital 7. You'll see that
7.
Recital 17. You'll see a distinction, of course, between the union citizens and family members. The right of permanent residence concerns both, as long as they reside in the host member state in compliance with the directive for 5 years. Without becoming subject to an expulsion measure. Then recitals 22 and 23 are about restrictions on the rights on the grounds of public policy, public security, and public health.
'23 and '24 are potentially relevant.
Yes, and 24 and 25, yes.
In 24, where it talks about exceptional circumstances where there are imperative grounds of public, only in exceptional circumstances where there are imperative grounds of public security should an expulsion measure be taken against union citizens who have resided for many years in the territory of the host member state, in particular when they were born and have resided there throughout their life. I mean, it doesn't tie being, I mean, it talks about in particular being born and resided throughout life, but it doesn't say that they have to have had the status of union citizens from birth, does it?
No.
Or go through residence throughout their life. It's simply, that's simply talking about a chronological link, isn't it?
Yes.
I.e. integration through a chronological residence.
Yes.
Yes.
And 25 is about procedural safeguards and the principle that any action must be properly justified. I think these are the recitals that are conceivably relevant to the articles that you're going to look at. So chapter 3, which you have at page 9, concerns the right of residence.
Should we look first at the definition of family member? Article 2.
Yes. Yes. So page 7. There is you'll see a definition of a union citizen and family members. There's no dispute about the definition. Family members.
Family member if you're a direct descendant
Yes.
and under the age of 21 or dependent on
Yes.
somebody who's a union citizen.
Yeah.
Do we know whether Mr. Borg, I don't know how you pronounce his name, is it Borges or something, was
Burgess.
dependent on his parents after the age of 21, or is that just not dealt with in evidence? Because one would assume he stopped being a family member for this purpose when he was 21.
That is right, but subject to this, that of course he came here as a family member of his father in 2002.
Yeah.
And he was issued with a residence card until 2006,
Yeah.
which was extended until 2011. Um, and that is the factual basis on which the tribunals below made their decisions, and the factual basis on which you'll make your decision. It's essentially common ground that his residence was a residence pursuant to the directive and the regulations.
Does the definition of union citizen have any relevance? Any person having the nationality of a member state?
Well, yes, that is what union citizen means. I'm not sure if ultimately it assists in relation to the question that you'll be looking at.
Right. So you wanted to take us to chapter 3? Did you?
Yes, chapter 3. Yeah. So chapter 3 concerns right of residence. And you'll see that Article 6 concerns the right of residence for up to 3 months. And Article 7 deals with right of residence for more than 3 months. So the way in which the scheme was intended to work was that a union citizen would be free to travel to the UK without any conditions or formalities, and would be entitled to reside here for up to 3 months. If the union citizen then becomes a worker or a self-employed person or falls under any other provisions, then the union citizen will have a right of residence for more than 3 months. And if the union citizen then continues to reside in another member state in accordance with the directive, being self-employed or a worker, falling under any other categories, that union citizen would acquire the right of permanent residence after 5 years. And that is Article 16, which you have at page 25. Yes, Article 16,
Page
page 15.
15. Yeah.
So 16.1 concerns union citizens who have resided legally for a continuous period of 5 years in the host member state. They shall have right of permanent residence there. And once they acquire permanent residence, then that right would not be subject to the conditions in chapter 3. And that also applies to family members who are not nationals of a member state and who have legally resided with the union citizen in the host member state for a continuous period of 5 years. So union citizens and family members are dealt with separately in Article 16. As I submitted, the scheme was intended to work in a staged manner. Initial 3 months residence for union citizens. If they then becomes workers, self-employed persons, they'll get residence for more than 3 months, and then permanent residence after 5 years.
So would you submit that 16.1 right can only be acquired by a person who's been a union citizen throughout the 5-year period that's referred to in 16.1?
Yes.
And you would say that the same applies, obviously, in 6.1 and 7.1.
Yes.
And you would say it must mean the same thing in all 3.
Yes.
And it means any person having the nationality of a member state.
Yes.
So we read that in. any person having the nationality of a member state shall have the right of residence on the territory of another member state for a period of up to 3 months in Article 6, and the same in Article 7.
Article 6 and 7 refer already to union citizens.
Yes, I'm just thinking aloud, putting the definition from 2.1 in lieu of Article Union citizens. I mean, the phrase is different in 6 and 7 on the one hand and 16 on the other.
Of course, there is a difference in the language, because 6 deals with the initial period of residence, 7 deals with the residence between 3 months and 5 years, and 16 concerns residence after 5 years, essentially. So the point, as my lord rightly pointed out, is and that is the submission that a union citizen who resides in the UK as a union citizen for a period of 5 years, in accordance with the directive, acquires the right of permanent residence.
So, can I just, sorry, I'm probably being the slowest boat in the convoy here. If you look at Article 16,
Yes.
you say the right under 16.1 for a union citizen only arises if and when the union citizen has been continually resident for a period of 5 years in the host member state, during which time, at all times during which time, they have been a union citizen.
Yes.
Right. How do you apply, then 16.2
Yes.
says paragraph 1 shall apply also to family members who are not nationals of a member state and have legally resided with the union citizen in the host member state for a continuous period of 5 years. So how does that work?
Well,
What's the position with people who are not members of a national state? How do you read 16.2?
so if a union citizen arrives, say, in the UK with a spouse who says is an Indian national, they both will have the right of residence for 3 months. If the union citizen then becomes a worker or self-employed person, then they both will have a right of residence for more than 3 months. So once they reside in the UK continuously for 5 years, the union citizen will acquire permanent residence under Article 16.1, and the spouse will acquire permanent residence under Article 16.2. So that would be a paradigm case of the application of this article.
Okay.
But Article 16.2 doesn't, at least on its face, it only relates to continuous residence for 5 years by somebody who, by definition, is not a union citizen.
Yes, but
you say that it has to be piggybacked some way onto somebody who is.
yes, because
Yes,
of the
yes.
word, because of the phrase family members.
If we put, I know this is rather tedious of me, but if we go back to the definition, so every time it says union citizen, we put a person having the nationality of a member state.
Yes.
So let's start with 16.2, as that's where we've landed.
Yeah.
If instead of union citizen in line 2 of 16.2, you put a person having the nationality of a member state,
Yes.
what you're then saying is that paragraph 1 applies to family members who aren't nationals if they have legally resided with a person having the nationality of a member state
Yes.
for a continuous period of 5 years.
Yes.
So that, and you say that fits with your interpretation.
Yes.
And the point is that in order to be a person who can qualify for the right under Article 16, you have to have been a union citizen who came here in the first place, exercising your treaty rights.
Yes. Yes. Of course, in this case, there is no dispute that Mr. Borges
No.
had permanent residence because he resided in the UK
Yes.
as a union citizen for a period of 5 years from 2014 to 2019. In 2019, he acquired the right of permanent residence under Article 16.1. But of course, this is the context in which you will look at the actual article that is relevant, Article 28.
Yeah. Okay.
So this is how, in my submission, the scheme works. You then go to Chapter 4, which you have at page 19. Well, this chapter concerns restrictions on the rights of entry and residence.
Sorry, I'm just going to come back to this. I'm just trying to figure it out. Suppose you have somebody who is a union citizen who comes here and resides for 5 years, has a period of residence for 5 years. At the end of the 5 years, you say they get the right of permanent residence under 16.1.
Yes.
If they are joined after, say, 2 years or 3 years,
Yes.
by a spouse. So at the end of 5 years, the union citizen gets the right of permanent residence. The spouse only gets it after year 7 on my
That's right.
analysis.
Absolutely.
Right.
Yes.
And okay, and we're not dealing at the moment with anybody who has become a union citizen during those years. We haven't got to that complication yet.
Yeah. But can I perhaps just give another example that would sort of illustrate the point, and in my perspective submission, the difficulty in the argument that is being made against the Secretary of State. So take the example of an Indian national who comes to the UK as a student or as a visitor. He then resides in the UK for 4 years as a student. And in year 5, there's a marriage between that person and a union citizen. A union citizen who is already in the UK. On the case that is being made against the Secretary of State, that family member would acquire permanent residence 1 year after the marriage, as soon as they complete 5 years in the UK, irrespective.
Well, why is that? Because they wouldn't have resided with the union citizen on your
Yes, for a continuous period of 5 years. So the point that I'm seeking to make is that the way in which the scheme works is that if you're a union citizen, you've got to be in the host state as a union citizen for 5 years before you get permanent residence. If you're a family member, then you've got to be a family member of a union citizen residing together in the host state for a period of 5 years before you become eligible for permanent residence. That is how the scheme, in my respective submission, is intended to work.
Yeah, but that's right. I mean, you can only, is this right? You're saying you can only count your year's residence for 16(2) purposes if you count years during which you have been both a family member,
Yes.
as it were, so, and have legally resided with the union citizen.
Yes.
So I wasn't sure I was following your example of somebody who
Yes.
married a union citizen after having been here as a student for 4 years because they wouldn't have been a family member for 5 years.
Yes. Lord, may I show you articles 27 and 28? Because that may assist in relation to the example that I'm seeking to give. So 27 and 28 are about restrictions on the rights, and there is a general principle at Article 27(1), which is that the member states may restrict the freedom of movement and residence of union citizens and their family members, irrespective of nationality, on the ground of public policy, public security, and public health. And you then have Article 28 that provides a 3-tier system of protection against expulsion. The first tier is reflected in Article 28(1). Now that level of protection is acquired by a union citizen as soon as they arrive in a host state, or a family member as soon as they arrive in the host state with a family member. So before an expulsion decision is taken, the host state shall take into account certain considerations. The middle tier, or tier 2 protection, is provided by Article 28(2). And you'll see that 28(2) refers not only to union citizens, but also to their family members. And it says categorically, irrespective of nationality, who have a right of permanent residence in its territory. So once you have a right of permanent residence, then you may not be expelled except on serious grounds of public policy or public security. And you have seen articles that concern right of permanent residence. So with that context in mind, you'll then look at Article 28(3) that, of course, the court is dealing with. And that provides the highest level of protection against expulsion. And you'll immediately see the difference in the language between Article 28(3) and Article 28(2). So 28(2) refers to union citizens and family members, whereas 3 refers only to union citizens. The phrase irrespective of nationality, which appears in Article 28(2), is missing from 28(3). So an expulsion decision may not be taken against a person having the nationality of a member state. Supplying the formula of Lord Justice Baker, essentially inserting the definition that you have in Article 2 there. The imperative grounds test would apply if they have resided in the host state for the previous 10 years.
Yes.
And the short submission is that when you look at this provision in the context, what it means is that you've got to have a residence of over 10 years having the nationality of a member state.
And there is a difference, another difference between the wording, I don't think you mentioned this, the difference between wording of 28.2 and 28.3 is that 28.2 talks about the citizen who has the right of permanent residence,
Yes.
whereas 28.3 talks about the union citizen if they have resided for the previous 10 years. So the trigger to 2 is the right of permanent residence,
Yes.
whereas the trigger for 3 is if they have resided for a period 10 years. Does that make any difference?
Well, it makes no difference to the argument that I'm seeking to make,
No.
because the argument is that, I said, you got to have 10 years residence, having the citizenship of member state as Article 2 says.
It's not continuous residence, is it?
It is continuous.
Why doesn't it say so?
Yes, because there is
Definition.
a definition of that, what amounts to residence. And I'll take you to that definition, but can I just respectfully invite my lady and lords to consider the example that I was seeking to give earlier by reference to this provision. So an Indian national comes to the UK, say as a student, resides here for 9 years or 10 years as a student, 9 years. He then acquires citizenship of European Union. On the argument that is made against me, that person would acquire the highest level of protection, despite the fact that that person has not resided in the UK for 10 years, having citizenship of European Union.
Well, the argument against you is based on the premise that the right comes from the status as union citizen, irrespective of the time which they've had it.
Well, the right in my submission comes not only from the status of being a union citizen, but also by the right, by the residence of 10 years as a union citizen.
Are you saying, just to be clear, are you saying that because you present this as a sort of tiered system of protection, are you saying that you must read into Article 28.3 some of the language from 28.2? I'm just trying to be clear how it works. So 28.2 says the host member state may not take an expulsion decision against union citizens, forget family members for a second, who have the right of permanent residence on its territory. So as far as union citizens are concerned, 28.2 talks about union citizens who have the right of permanent residence on its territory. So you look back to find out how they might have acquired that right of permanent residence. So you look back to Article 16.
Yes.
So that's somebody who's resided legally for a continuous period of 5 years.
Yes.
And there are provisions about what may or may not break continuity of residence.
Yes.
Right, so you then move to 28.3. An expulsion decision may not be taken against union citizens if they have there's the protection if they have resided in the host member state for the previous 10 years. So it says nothing about right of permanent residence or continuity of residence, at least on its face.
No, but the way in which the scheme works is that
Would you read in sort of something, anything to do with permanent residence or continuity of residence?
I'm not asking the court to read anything in Article 28.3, but the point is that you get to Article 28.3, you have 10 years residence if you have already acquired permanent residence after 5 years of residence.
So in other words, the premise of Article 28.3
Yes,
is that you have already been through the hoop
absolutely.
of acquiring permanent residence
Yes.
via Article 16.
Yes,
Which is what I was sort of asking you, really.
Yeah.
yes,
Yeah.
I was-
and
I'm just trying to there is no loaded gun here. I'm not making
I
a
see.
point, right? I'm
Now,
just
yeah.
on a voyage of
Yeah, so-
discovery.
yeah. So when you will look at the regulations, you'll see that the point is made more clearly in the regulations that you'll only get to 10 years residence if you have already acquired permanent residence after 5 years and then stayed on having the nationality of another member state for another 5 years.
Yeah. I mean, it doesn't say that, does it? 28.3 does not say that in terms. It's in terms are different.
Yes, and it really comes down to how you construe 3A, have resided in the host state. The submission is that you read that phrase together with the phrase union citizen, as appears earlier in that article, having regard to the definition that you have looked at in the context of the scheme that I've sought to outline.
So
Can
is
I-
it- sorry. No, you
Can I take you back to I know this is not helpful. As usual, we're all bombarding you with different questions from different angles. I'm sorry. But can I take you back to Article 16?
Yes.
I know you said an hour and a quarter. We're not gonna hold you there. Article 16, what does legally mean there? Might be a stupid question. Does it mean in accordance with articles? Does it have any relevance to any link with Article 9?
Yes. Yes.
9.
Yes.
Where was it?
Article 6 and 7.
Article 6 and 7.
Absolutely, the regulations make that point clear.
Okay.
If, for example, a union citizen comes to a host state for 3 months, but decides to stay on without working or without being self-employed or falling under any other categories, then that union's citizen's residence would not be lawful in the sense that it would not be in accordance with the directive. And that union citizen will not acquire permanent residence after 5 years.
Yeah.
So you acquire permanent residence only if you reside here as a union citizen exercising treaty rights.
So, if, and I'm not expressing a conclusive view, but if under Article 6 and 7, it's clear that union citizens there means a person having the nationality of a member state, and they have to have a nationality of a member state from the day they start the period.
Yes.
If that's true of Article 6 and then true of Article 7, it's also therefore true of Article 16
And Article 27, yes.
and ergo Article 27,
Yes.
and therefore you say Article 28 2 and you say 3.
That's the point, yes.
So do you, in order to qualify under 28.3, does your residence for the previous 10 years have to have been legally and continuous?
Yes.
So if you hadn't been exercising treaty rights for past that 10-year period, then it couldn't count.
Yes. Yes. Can I show you the regulations, because the regulations state things a little more clearly.
Okay. I invite us to interpret the directive by virtue of the regulations.
The question before the court is about, in my submission, construction of the regulations as opposed to
Okay.
construction of the directive. When I showed you directive because the regulation essentially transposes the directive into the domestic law,
Okay.
but it's not suggested by anyone that there is a difference between there's a material difference between the regulations and the directive. But when you'll come to the question of interpretation of the regulations, you'll have an understanding in my respect submission of how the directive works.
Okay.
So regulations, tab 2.
So, sorry, can I just ask a general question? I'm so sorry to interrupt, Mr. Malik. Does the fact that the United Kingdom's left the European Union make any difference to this question of construction? That's just an open question. I don't know what the answer is. No. Okay. Thank you.
Okay. Regulation.
Yes, tab 2.
Yeah.
If you look at part 1, that provides definition of certain phrases. This is page 27. If you look at page 28, you'll see the definition of the phrase EEA decision.
Yes.
And the EEA decision means a decision under these regulations that concerns the relevant limb is C, a person's removal from the United Kingdom. You then have the definition of the phrase EEA national. And that means a national of an EEA state who is not also a British citizen. There is another limb that does not apply. But an EEA national means a national of an EEA state who is not also a British citizen. If you then look at page 30, you'll see regulation 3 that concerns continuity of residence. And it tells the reader as to how to calculate continuous residence in the UK under the regulations. You look at 3.3, it says that continuity of residence is broken when A, there is a prison sentence that is not relevant in this particular case, but B, when a deportation or exclusion decision is made. So as soon as a deportation or exclusion decision is made, that brings an end to the continuity of the residence.
So why do you say 3A is not relevant in this case? If continuity of residence is relevant to this case, then 3A would be relevant.
So the reason why 3A is not relevant is because of the exception that you have in regulation 3.4.
Okay.
It refers back to breaking of the residence under 3.1 and says that an EU national who has resided in the United Kingdom for at least 10 years, but it does not apply where the Secretary of State considers that, and then there are 3 limbs. Now, in this particular case, there is a finding by the tribunals that continuity of residence was not broken by the sentence, essentially because of the exception that you have in 4. That conclusion was not challenged, and I'm not seeking to go beyond that conclusion.
Slightly difficult to understand why not, but anyway, that's not a matter for us.
So there was no appeal on that point from the First Tier Tribunal to the Upper
that.
Tribunal, and it's too late for me to seek to make that point. But you'll see that the exception that you have in 4 concerns only 3A. There is no such exception in relation to 3B. So where there is a deportation or exclusion decision that brings an end to continuity of residence in an absolute manner, there is no discretion in the way that there is a discretion in relation to sentence.
So that deals with the respondent's notice, does it? Does that deal with the respondent's notice then?
Yes.
Yeah.
Yes.
Why does section 3, paragraph 3.4, regulation 3.4. Paragraph 3A applies in principle to an EEA national who has resided in the UK for at least 10 years.
Yes.
You say that doesn't apply to this case in any event. Because Mr. Borges hasn't resided in the UK for at least 10 years on your view of the world. Because he's not been an EEA national for at least 10 years.
That's right, of course.
So, in a sense, why you say we don't even get into it? Why have people been worrying about this then on your or reaching conclusions on this?
Yes.
On your analysis, none of this is relevant at all.
No, but the way I read the underlying decisions was that two separate points were made. The first was that the continuity of residence was broken in 2019 because of the prison sentence. The tribunals ruled in favor of Mr. Borges on that particular point.
And you've not taken it any further.
Yeah. The second point is that the continuity of residence in any event came to an end in 2022
When you made the
the
decision.
deportation decision was taken.
Yeah.
So the residence of Mr. Borges up until 2022 as an EEA national was 8 years, not full 10 years on any view.
But is your point that continuity of residence only applies to continuity of residence whilst having a status as an EEA national?
No, because 3.1 makes it clear that this regulation applies for the purpose of calculating periods of continuous residence. So it applies generally.
Yes, so it
So
precisely. So this will apply.
So this bit of the regulation doesn't have the condition attached to it that you say that the deportation rights regime has attached to it.
No. So this provision applies as Milady rightly pointed out to everyone, whether or not they have 10 years residence. But what was made clear by 4 is that this would apply also to those who have resided here for 10 years, subject to the exception.
Right, so that's 3.
That's the. You then have a definition of the phrase qualified person in Regulation 6. This is page 33. So the fact that you are an EEA national is not enough to get extended rights of residence. You must also be a qualified person. And you'll be a qualified person if you are an EEA national and if you are in the UK as a worker, as a self-employed person, job seeker, self-sufficient student, etc. And this will be relevant when you will look at the regulations about extended rights of residence and permanent settlement, permanent residence. Those rights are only given to those EEA nationals who are qualified persons.
Right. Yes.
Regulation 7,
Family member.
family members, reflects what the directive says. There's no dispute here that Mr. Borges was a family member initially. Part 2 of the regulations concerns rights. You have that at page 43. Now you'll see that the phrase EEA national is used in Regulation 11.1. So whether or not you are a qualified person, whether or not you are working here or job seeker, as long as you are an EEA national, you have a right of admission, the initial right of admission. That right is not dependent on you exercising treaty rights in the country. Now, the extended right is dealt with in Regulation 14. page 47. And you'll see that the phrase "a qualified person" is now used.
Sorry, which
Regulation 14,
Yes, thank
page
you.
47. So you only get the right to reside here for more than 3 months if you are a qualified person. And under 14.2, the family member of a qualified person also gets the right of extended residence.
So long as they remain a family member.
Yes. Yeah. And 14.2 may assist with the example that was being put to me earlier. You see that 14.2 has 2 limbs. The first limb is where a qualified person, where a family member is residing with a qualified person. The second limb is where a family member is residing with an EEA national with a right of permanent residence. So once an EEA national acquires permanent residence, then there's no need for that person to continue working in the UK or being self-employed or job seeking in order to have right of residence.
I'm just going back, reminding myself, qualified person means a person who is A, an EU national, and B, either a job seeker or worker, etc. Yes?
So permanent residence is dealt with by Regulation 15. You have that at page 48 of the bundle. An EEA national who has resided in the UK in accordance with these regulations for a continuous period of 5 years acquires the right of permanent residence. So an EEA national comes to this country for 3 months. He then becomes self-employed, a job seeker. He works, continues to work for 5 years. After 5 years, he acquires permanent residence, as long as, in my submission, he has a residence of over 5 years as an EEA national. The family member also gets the right of permanent residence under 15.1b, as long as they have resided in the UK with the EEA national in accordance with the regulations for a continuous period of 5 years.
So in accordance with the regulations means
The union citizen would be a qualified person for the period of 5 years, and the family member would reside with the union citizen.
okay. Right. So once again we go back to the definition of qualified person, which on your case you only become a qualified person if you are inter alia, an EEA national and you're working, etc.
Yes. So in other words, if an EEA national comes to this country for 3 months and just stays on for 5 years without working, without being a student, a self-employed, a job seeker, that EEA national will not acquire permanent residence after 5 years, because the residence of that EEA national would not be in accordance with the regulations, and the same would apply to the family member.
And so, for example, if a child had lived with a parent who was a qualified person, but ceased to be a child, so in other words, attained the age of 21 before they'd been living here for 5 years, they wouldn't get the right of permanent residence under 15, or would they?
There are provisions in the regulations about retained rights.
Right.
But perhaps another example would be where there is, say a divorce or a spouse ceases to be spouse of.
There are special provisions about that, aren't there?
Yes.
Can you start off as a family member and then when you cease to be a family member, can you carry over the period that you've been a family member to complete your 5 years, or do you don't have to go back to the beginning again? So let us say you don't get up to 5 years under 15B. Can you carry forward the period you have been under 15B as part of a in any other way to acquire permanent residence?
Well, in principle, yes. I mean, you may acquire permanent residence by another mean, but for the purpose of 15(1)(b), you've got to have residence of 5 years as a family member of an EEA national.
So if you've got less than 5 years as a family member of an EEA national, you don't get the right to permanent residence.
No.
Okay.
Right. Okay. Right. Where do we go next?
Yes, so with this context in mind, you then look at part 4, page 56, which concerns
Exclusion.
expulsion and removal. And if you look at regulation 23(6), an EEA national who has entered the UK or a family member of such a national who have entered the UK may be removed. It's right at the end of page 56. And if you look at the next page, the Secretary of State has decided that their removal is justified on the grounds of public policy, security, and public health. But it's 23(9) that provides an answer, in my respective submission, to the point made in the respondent's notice, that a decision taken under paragraph 6(b) or (c) has the effect of terminating any right to reside otherwise enjoyed by the individual concerned. So when in 2022, the Secretary of State decided to remove Mr. Borges, that decision terminated the right that he had to reside here permanently. So he acquired permanent residence in 2019, and that right was terminated in 2022 when he was short of 10 years. In the UK as a union citizen.
Okay, can we just go back to this? Sorry, we got it. 23(6) is where we started here.
Yes.
So, subject to paragraph 7 and 8, an EEA national who has entered the United Kingdom may be removed if.
Yeah.
Does that mean an EEA national? Does this only apply to somebody who was an EEA national when they entered the United Kingdom, or does it apply to somebody who has become an EEA national after they entered the United Kingdom? Is this a status? To put it in other words, my lord, put it to you. Does 6 apply to somebody who has the status of the EEA national at the time you decide whether they can be removed, or does it only apply to people who are EEA nationals when they enter the United Kingdom?
Well, it would apply not only to those EEA nationals who entered the UK as EEA nationals, but also to those who acquire EEA nationality thereafter. If that isn't the case, then it just wouldn't be possible for the Secretary of State to deport any EEA national. Yes.
Right. So when we start looking at this, we're looking at people who have become EEA national, and the time at which you apply that question, or you answer that question to apply this, is when you are determining whether to remove them.
Yes. Regulation 27. This is the regulation that that court is dealing with. Is at page 60. you'll see that the phrase relevant decision is defined in 27.1. That means any EA decision. You have the definition of an EA decision earlier in part 1. Means an EA decision taken on the grounds of public policy, public security, or public health. 3 concerns the serious grounds test. And you'll see that 27.3 refers to a person. There is no reference or distinction between an EEA national, a qualified person, a family member, or a national of another country. A relevant decision may not be taken in respect of a person, but irrespective of who they are, irrespective of their nationality, as long as they have right of permanent residence under Regulation 15.
Well, the person with the right of permanent residence under Regulation 15 includes an EEA national.
An EEA national.
It's a requirement to be a person with the right of permanent residence.
Well, not only an EEA national, but family members may also require
Yes.
permanent residence.
Yes, I see. So it includes yes.
So it includes
Either it's one of the people listed in 15.
Yeah. So you get the
Thank you.
serious grounds protection, irrespective of your nationality, as long as you have permanent residence.
I've got it. Thank you.
But you'll see, in my estimation, a remarkable difference in the language that is used at 27.4. Because 27.4 does not use the phrase a person. It says a relevant decision may not be taken except on imperative grounds of public security in respect of an EEA national. So the highest level of protection is available not to a family member, not to a person of any other nationality, but only to an EEA national. The further condition is that EEA national, and this is the point that wasn't immediately clear from the directive, who has a right of permanent residence and who has resided in the UK for a continuous period of at least 10 years prior to the relevant decision. And this is the point that I was seeking to make when I showed you the directive, that the scheme is that before you get 10 years residence, you would have already acquired permanent residence under Regulation 15. And the residence must be continuous. You have the definition of that phrase in the part of the regulations that I've shown you. And then you got to have that period of residence prior to the relevant decision. And the relevant decision is defined in 27.1. So this is the words "the relevant decision" in mass mission provides another answer to the point in the respondent's notice. The residence after 2022, after the relevant decision, may not be included in the calculations in any event.
Right.
And an EEA national will get the highest level of protection if they have resided in the UK as an EEA national for 10 years prior to the relevant decision. Yeah. So
when was the phrase in square brackets added? F64. Doesn't matter. It was added.
Yeah.
64.
F6 2018.
Yeah.
So before that revision,
yeah,
those words weren't there.
Yes, but that in my submission was the effect in any event that you get 10 years residence only after you acquire 5 years residence. But it doesn't matter on the facts of this case because these are the words that are used.
So you say that amendment simply makes express something that's already implied.
Yes,
But it does make it express.
it does, of course. Yes.
So in order to qualify for that, you have to have a right of permanent residence under Regulation 15.
Those words potentially query whether they make a difference, but they may on one view be important because they bring back the reference to paragraph 15, which includes the words which you have stressed in accordance with these regulations.
Yes. Yeah.
And then the second thing that may be important in this 74 is something which I suppose has always been there, which is the reference to a continuous period, which was missing from the directive.
Yes.
Pointed out.
Yes, but the words continuous period were already there before the 2018 amendment.
They were. That's right. So it's by one reason or one route or another, we've arrived at
Yes.
something which I think you say simply makes express what was already implicit in the directive
Yes.
and express what was, you say, implicit in the directive and implicit because there was an implicit reference back to 15.
Yes. So the ultimate submission is that you'll read Limbe with the words EEA national in the proper context. So if you have 10 years residence having the nationality of a union state, and if you have permanent residence, you then have the highest level of protection.
I suppose it's a fond, my fond imagination may lead me to ask the next question. Did anybody say anything when they introduced the Immigration European Economic Area Amendment Regulations in 2018 to explain why they were putting those words in? Or is that just too much to hope for?
It's not my Lord's sole fond imagination. I share that imagination. The same thought was going through my head. Why would they add it?
Yes.
Why, what would be the point of adding it if there wasn't a...
Is there an explanatory?
There is an explanatory note, pages 90 and 91. Yeah, page 91, fourth last paragraph, which concerns amendments to Part 4. But I'm not sure if there is something directly on.
I think this might be the explanatory note that was issued with the 2016 regs.
The lady's asking about the explanatory note, if any, for the
When
amendment.
the SI,
28.
when the SI, which made the amendments in 2018,
Yes.
called into force, so there ought to be an explanatory note or an explanatory memorandum. So it might help us, please, if you could
We'll
see if you can
find that.
find it.
Absolutely.
Thank you.
I know you say that the words in square brackets didn't make any change, subject to. Let's see what the explanatory memorandum says about that. But your case is, it makes it clear.
Yes.
Because it refers back to Regulation 15, which requires residence in accordance with these regulations for a continuous period.
Yes. So that really is ground one.
Do we need to look at what the tribunal said about that?
But this is really a question of construction. There's only one right answer. It's for you to decide. What the correct construction of this provision is.
Melanie was looking at me to indicate that she agreed with you on that point. But I would actually like, for my pander to my eccentricities, Mr. Malik. Why did this all go wrong in front of the tribunal?
Yes. So may I show you the relevant part of the Upper Tribunal's decision then?
Yes.
Yeah.
Thank you.
There isn't, with respect, much analysis in that decision. So it's page.
Do we need to
75.
start with the FTT, or do you say
no,
that's been superseded by the Upper
No,
Tribunal?
perhaps for the purpose of this point, you simply look at the Upper Tribunal's decision,
Okay.
and it's page 75 of the core bundle, and paragraphs 38 and 39. 38 says that the regulations do not expressly say that an EEA national must have resided in the host state as an EEA national exercising treaty rights for the whole of the minimum 10-year qualifying period. Of course, the regulations do not expressly say that.
Well,
that makes no
it
difference.
goes on to say, in that respect, it contrasts with Regulation 12 and 15. But Regulation 15 is an integral part of Regulation 26, as you've just established, isn't it?
Yes, but
For present purposes. I know you don't think the words in square brackets are crucial, but
if you look at the end of that paragraph, you see that in my respective submission, the Upper Tribunal effectively inserted words in the regulations that do not exist.
which words do you say that they've inserted?
Effectively inserted three lines. If you look, the language of Regulation 27 means has acquired the minimum period of continuous residence, and then what is said subsequently is effectively inserted in accordance with the 2016 regulations.
Whether such, blah, blah, blah. So that's a gloss, you say?
That's a gloss in insertion. And whether such residence has been accumulated as a family member of an EEA national exercising treaty rights or as an EEA national exercising treaty rights, provided that the individual facing removal is an EEA national at the date of the removal decision. So we don't see those words in the regulations. The Upper Tribunal effectively inserted those words.
Is there a confusion in the previous paragraph, paragraph 37, where the Upper Tribunal will refer to the submission that the enhanced protection only applies to those who've acquired permanent residence, and then they say, present case, the appellant undoubtedly had acquired such residence, but the submission may have been it only applies to those who'd acquired permanent residence as an EEA national throughout in the way that you've explained in your submissions. I don't know, maybe not.
I think what Ms. Everett was seeking to say is that the enhanced protection would apply if you have permanent residence, and then in addition to that, 10 years residence. But 38 reflects in my respective submission, inserting words in the regulations that are not there.
Right. So that's how the UT dealt with it.
Yes, and the conclusion is at paragraph 40. And you'll see that that reflects the paragraph that you've just looked at. And you'll see that effectively 4 or 5 lines are artificially inserted in the regulations. And for these reasons, I submit that well, this construction is wrong in law. I've already dealt with the point that was made in the respondent's notice.
You have.
That the appeal is academic. So these are my submissions essentially on ground one.
Yeah. Ground two.
Ground two. Can I just take you back to?
Can I just intervene for a second? The explanatory note to the 2018 change by which those words were added say that they were added as a consequence of the decision of the ECJ in a case called Vomereau,
Which is mentioned in the Upper Tribunal's decision.
yeah, which I'll just give the reference, which is C42616, and it followed a Supreme Court decision by the look of it, which was 2019 UK SC 35. I'll just mention that. Obviously, I'm trying to listen to you and also look at that. So I will now stop looking at that. Resume listening full time to you, but I mention it just in case it's relevant to anybody.
Well, the case was that case was cited in, as it says in paragraph 37 of the Upper Tribunal decision.
Yes, but there's no dispute in this case that you've got to have the right of permanent residence before you acquire the highest level of protection.
Yes. What I don't know is which bit of Vomereau led, or why it led to the insertion of those words, other than that is the explanation that's given.
So Vomereau's FV Italy, is it, which is at tab 4, is that right?
Yes, and we'll find that issue precisely the provision and why these words were inserted.
For some reason, the Court of Justice decided it needed to anonymise all the litigants, which just makes life very difficult.
Like a family case.
No, in every single case virtually. They used to have their names, and then at some point the CJU decided, no, we need to anonymise them. Anyway, so we can look at Vomereau to see what that decides.
Yes. Not sure if you'll get much assistance in that judgment in understanding why the words were inserted, but we'll check the position over lunch.
What's the Supreme Court decision? Subsequent decision in Vomereau.
Yes,
That referred to above. I missed that.
yeah. It was Robinson. I think it was Robinson,
UK,
but I do not want to give.
The decision of Vomereau, the Supreme Court's subsequent decision in Vomereau
Yes,
is referred to in paragraph 35, UK SC 35.
yeah, it's paragraph 44.
I'm just reading the head note in FV Italy, and it makes clear that what the court decided was that it was a prerequisite for the enhanced degree of protection that you had a right of permanent residence.
Yeah.
So that's a clear decision.
Yeah. So page 78 of the bundle, paragraph 44.
Okay.
Now, on ground 2, may I just take you back to the regulations and show you the provisions that are relevant to ground 2. So you have looked at Regulation 27, page 60, at the first part. 27 5
Yes.
Says that the public policy and public security requirements refer to those requirements and say that a decision must be in accordance with these principles. The decision must be proportionate. This is A, 5A, and C. The personal conduct of the person must represent a genuine, present, and sufficiently serious threat to one of the fundamental interests of the society, taking into account past conduct of the person, and the threat does not need to be imminent. But what is directly relevant in my submission is 27.8, which says that a court or tribunal, considering whether the requirements of this regulation are met, must, it's an obligation, in particular have regard to considerations in Schedule 1. So there is an obligation on the decision maker to have regard to those considerations. Failure to have regard to those considerations would be inconsistent with the regulations, would amount to an error of law. Now, Schedule 1 is at page 76. One concerns margin of appreciation. 3 is relevant here, where an EEA national has received a custodial sentence or is a persistent offender. The longer the sentence or the more numerous the convictions, the greater the likelihood that the individual's continued presence in the UK represents a genuine, present, and sufficiently serious threat affecting the fundamental interests of the society. That is a relevant consideration which wasn't considered at all by the tribunals. And then if you look at page 77, you'll see that 7 sets out matters that are fundamental interests of a society. B is relevant, maintaining public order. C is relevant, preventing social harm. F, you'll see concerns maintaining public confidence in the ability of relevant authorities to take action. My submission, if the Secretary of State is not able to deport a person like Mr. Borges, continues to commit crime despite 2 warning letters, despite an earlier deportation decision, then that will have an impact on maintaining the public confidence in the ability of the Secretary of State to take action. G, offences likely to cause harm to society. H is combating the effect of persistent offending. And then J, protecting the public. The decision maker is obliged to engage with these matters.
It's a bit like the provisions of Part 5A of the 2002 Act.
Yes, and this is the point that I think Milady made recently in another case, that this yes.
Like a crack record.
Yes. Yeah. Yeah.
I just, was there an element of bootstraps in your submission about the last bit of F? I mean, you can't say the public want confidence in the ability of the relevant court to take such action if, on its true interpretation, such action is not open. I mean, what do you mean? You can't. I mean, if it's not open to the Secretary of State with all the relevant authorities to take such action because it's just not the power, you can't bootstrap yourself up and say, well, they must now have it because.
I don't think that's the submission.
I'm not. That isn't really what you were saying, is it? No.
So
what do you?
So for the purposes of this ground,
Yes.
I assume that I'm wrong on ground one. This person has acquired the highest level of protection,
Yes.
and the decision maker has to decide whether there are imperative grounds justifying his deportation.
So this is one of the things that the decision maker, i.e. the FTT, must take into
must take
account
that's the
when
point, yeah. So
deciding whether the grounds exist.
Yeah, so in deciding whether there are imperative grounds justifying deportation, these are the matters that the decision makers must take into account. So it's not, so if a person has acquired the highest level of
Yeah.
protection, that does not mean that his deportation can never take place.
No, of course not. Yeah.
So it can take place where there are imperative grounds, and in assessing whether there are imperative grounds, these are the relevant matters to consider. Moving on then to the facts of this particular case, I have failed already in complying with what I had said earlier.
Yes, no, well, I anticipated that.
But the facts are set out pretty fully in the decision letter, aren't they?
That's right. So can I, rather than just taking you to every single relevant decision, can I just give you some references? So the first warning letter is at page 66 of the supplementary bundle. So this is the 2008 letter. Lady, if you wish to look at it, it's core bundle, page 66.
S bundle.
Yes, supplementary bundle. My apologies. Yes. So page 66. So Mr. Borges received a sentence was sentenced to 6 months. The Secretary of State says that, well, I've noted that. I'm not taking any action now, but I will consider deporting you if there are any further convictions. So he ignores that letter, commits further offences. And the Secretary of State then makes a deportation decision, which we have at page 68.
2011, is that?
Yes, sorry, 2012 deportation decision.
68, yes.
Yeah, this is following the 2011 convictions.
Yeah.
Paragraph 24 of that decision, the Secretary of State in 2012 took the view that Mr. Borges represented a sufficiently serious threat to safety and security of public, and his deportation was justified. The First Tier Tribunal disagreed, and you have the First Tier Tribunal's decision at page 75. And the paragraph that perhaps is relevant in the First Tier Tribunal's decision is paragraph 45, page 80 of the bundle. It proved to be a little optimistic. The First Tier Tribunal took the view that there was no genuine, present, or sufficiently serious threat. The risk of reoffending.
Where are you reading from now?
Paragraph 45 of the First Tier Tribunal's decision, page 80 of the bundle.
80.
Yeah. tribunal was saying that, well, he has now reformed, he has done well in prison, he has taken steps to reform his behavior. And the deportation would not be justified or proportionate.
And then there's a further warning letter on page 82.
Page 82, yes. So this is all that the Secretary of State could have done in the light of the First Tier Tribunal's
Yes.
decision to say that, well, your appeal is allowed.
Paragraph 46 of the FTT's decision is presumably also relevant.
Yeah. And then page 82, the Secretary of State says, well, the appeal is allowed, cannot deport you, but, and you have seen the text in bold, that if you commit further offences, we'll consider whether to deport you. You then have the latest deportation decision at page 108 of the bundle. This is page 108 of the core bundle.
Yeah.
Quite detailed decision. You have a detailed description of immigration history at page 111. And the history of offending at page 112. Can I ask you to look at paragraph 29, which is at page 114? The Secretary of State accepted that there is permanent residence because Mr. Borges had resided in the UK as a Union citizen, exercising treaty rights from 2014 to 2019.
Sorry, I missed the paragraph.
Yeah,
Struck by the paragraph.
Yeah, paragraph 29, which is at page 114.
Sorry, yeah.
And the Secretary of State then considers whether there are serious grounds for deportation and concludes that the deportation is justified. But you'd also want to see paragraph 37. This is the paragraph that Miller and Friend has picked. But it starts with the word consequently. The Secretary of State is not saying that there are no imperative grounds. The Secretary of State is saying that, well, because I do not consider that the imperative grounds test apply, I have not given consideration to whether the deportation is justified on imperative grounds of public security. This is because of the conclusion at paragraph 36, which is that Mr. Borges had not acquired 10 years continuous residence as an EEA national. So it's not that there was a concession by the Secretary of State. The Secretary of State did not consider that matter in the light of her conclusions as to the 10 years residence.
So the question for the FTT, in the light of all the material in the decision letter, was how it applied the considerations in Schedule 1 to what was revealed by the decision letter.
Yes. Before I take you to the First Tier Tribunal's decision, can I just show you the Secretary of State's review that was before the First Tier Tribunal? So the way in which things work in the First Tier Tribunal is that the appellant files their skeleton argument and evidence. The Secretary of State then files a written review of that evidence, and there is then a hearing. The review is in the supplementary bundle at page 139. If you look at page 141, the Secretary of State makes the point again that it's not accepted that Mr. Borges qualifies for enhanced protection. And there is no concession that there are no imperative grounds, but the point that is being made was that the imperative grounds test simply does not apply.
Sorry, whereabouts? Page
Paragraph
141?
7.
Paragraph 7,
Sorry.
page 141.
Thank you. Sorry, my fault. I'm being really slow.
We'll then look at the First Tier Tribunal's decision, which is in the core bundle. Starts at page 95.
Yes.
It deals with the issue of the residence, the permanent residence, the effect of the sentence, etc. But the conclusion is at paragraph 30.
Yes.
This is where the First Tier Tribunal finds that the appellant has 10 years continuous residence. We say that that is wrong for the reasons in ground 1.
Yeah.
And then that residence means, this is paragraph 31, that the imperative grounds test applies. Paragraph 32, the respondent has not put forward any imperative grounds for the deportation within either the refusal letter or oral submissions, obviously because the Secretary of State was saying that the imperative grounds test does not apply. Now, if the decision had ended at that point, that the position might have been different. That could have enabled the Secretary of State to produce another decision, another deportation decision, saying that, well, I've now considered the imperative grounds and your deportation is justified. But the problem then is that at paragraph 33, the First Tier Tribunal says that I find that there are no imperative grounds. And that conclusion with respect is simply indefensible. There is no engagement, none whatsoever, with Schedule 1 considerations. There's no engagement with the matters set out in the decision letter. And that conclusion surely is wrong in law.
Well, quite apart from anything else, the conclusion is asserted, but there's no underlying reasoning.
No.
And then you're going to take us to what the UT said about that?
Yes, but can I just show you the Secretary of State's appeal to the UT as to the grounds on which the Secretary of State sought to challenge their decision. That is at pages 90 and 91. Page 90, the first ground is that the imperative grounds test does not apply. That reflects the ground 1, that is before the court. But grounds 2 and 3 reflect the second ground of appeal before the court. The argument is that there is a failure to apply the principle of proportionality, failure to have regard to the principles in Schedule 7, failure to give reasons, failure to take into account material matters. The Upper Tribunal's decision on that ground, on those grounds, the relevant parts of that decision starts at page 79.
Yes. There were some submissions about, or they were called to the submissions made by Ms. Everett on behalf of the Secretary of State and then Mr. Karim.
Yes. So this is where in my submission the Upper Tribunal fell into a plain and obvious legal error. Now the task of the Upper Tribunal under the statute, this is section 12 of the Tribunal's Courts Enforcement Act 2007, is to consider first whether the First Tier Tribunal has made an error of law. second question that the upper tribunal, if the upper tribunal concludes that there is an error of law, the second question is whether the error was material to the outcome, whether the decision of the first tier tribunal should be set aside. Now, in considering the question of materiality, the test that the upper tribunal must apply is one of inevitability, which is that, well, the appeal would have succeeded in any event. It's not enough for the upper tribunal to say that, well, we might have reached a different conclusion. And once you conclude that the outcome is not inevitable, you set aside the decision. You then remake the decision. You then look at the arguments. You then decide whether there are imperative grounds. And any views that the upper tribunal expresses about the merits of the underlying case or the facts are irrelevant commentary. I think this is what my Lady Justice Elisabeth Laing said in one of the two cases that were drawn to the attention of the parties. This is precisely what my lady with respect was saying in ASO Iraq and MA Iraq. Paragraph 85 of MA and paragraph 59 of ASO. So instead of deciding whether there is an error of law in the first tier tribunal's decision, the upper tribunal sought to consider the merits of the underlying appeal. And then at 51, they said that they had some difficulty with the respondent's submission that the first tier tribunal ought to have considered whether there were imperative grounds. But there is no difficulty in my submission because the Secretary of State did not consider those grounds in the decision letter. But once the tribunal had found that that test applies, it was for the tribunal, it was for the judge to apply that test.
Can Schedule 1 have been drawn to the attention either of the FTT or of the Upper Tribunal in this case? Because it's very difficult to understand paragraph 51 if the Upper Tribunal was shown Schedule 1.
Yeah, no, the Upper Tribunal was certainly referred to Schedule 1.
Right.
And I say that because of the grounds of appeal to which I've just taken you to.
Yeah.
So those grounds expressly refer to Schedule 1 and make the point that there is a failure by the first judge to apply the principles in Schedule 1.
Doesn't the Upper Tribunal refer to it in paragraph 55?
Yeah. Now, this isn't, in my submission, the proper way to deal with the matter. So at 57, say this with respect. It's not entirely clear what the Upper Tribunal is doing. The question for the Upper Tribunal is whether the first tier tribunal has made an error on a point of law.
Yes.
And at 55, the Upper Tribunal is simply substituting its own view.
I went back to the submissions. I mentioned that a couple of minutes ago, at 49 and 50. On behalf of the Secretary of State, it was argued that if the Upper Tribunal concluded that the judge was correct to find entitled to the enhanced protection, so it was against the Secretary of State on what was then ground one, or is now ground one, the tribunal could decide whether or not the imperative grounds existed, and there would be no need for further hearing.
Absolutely so, yeah.
Mr. Karim argued that if we were to conclude there were no imperative grounds, we could proceed to remake the decision.
Yes.
But if we thought there was any potential imperative grounds, should be remitted.
So this is not what the Upper Tribunal did. This is not a remade decision. What the Upper Tribunal is not a remade decision. But the Upper Tribunal could have done, the Upper Tribunal could have set aside the first tier tribunal's decision as being wrong in law. Firstly, the Upper Tribunal could have said, well, there is an error of law in the first tier tribunal's decision, failure to engage with Schedule one considerations. The Upper Tribunal could have set aside the First Tier Tribunal's decision and could have then remade the decision as Mr. Karim invited it to do.
Sorry, I mean, I understand your point about failure to make a finding of an error of law. Just on the question of what the Upper Tribunal was doing, was it, if it had, as we followed the process, and had decided to remake the decision, are you saying that it didn't take into account the relevant material, given what it does at paragraphs 52 through to 55? Because 50, I mean, if you take those all together, I mean, certainly on the face of it refers to the relevant factors, doesn't it?
Yes, but the sort of primary submission is that this is not the Upper Tribunal remaking the decision.
No, I understand your point. I mean,
Yes.
I understand your first point is that they failed to take an essential legal step to give themselves the power to remake the decision.
Yes,
Is that right?
yes, that is the submission. Yes,
If they had done so,
yes.
then are you separately saying that what they went on to purport to do was inadequate or inadequately reasoned or expressed?
Yes, I am. That is the second part of my second ground. And
I thought that's what you were saying.
yes,
So, I mean, normally, if a tribunal says that they are referring to the relevant schedule, to the relevant regulations and set out an evaluation of the matter, are you saying that they didn't do it adequately, or just they didn't express the reasons correctly, or what's the answer?
yes. Well, this Lord, you're asking me this question on the premise that I'm wrong in the first limb.
Yeah.
Yes.
Because if you're right on the first limb, in a sense, you don't need the rest.
No. No.
If you're wrong on the first limb, I'm just trying to check out whether you're in addition or separately criticising the way in which the Upper Tribunal went about remaking the decision. I know you say they didn't remake it, but
Yeah.
they didn't follow the first bit. But
Yes. Yeah. Can I perhaps take you to the part of my skeleton argument that lists my criticism of this reasoning? Paragraphs 39 to 42 of my skeleton argument. So 39 submission is that this is a person who just keeps on breaking the law. Failure to have any regard to the warning letters, deportation action, receives lengthy custodial sentence. The paragraph 3 paragraph that I've shown you, there's no in modified submission engagement with the principle that more numerous the offences, or the lengthier is the sentence, the greater is the likelihood that a person's presence would constitute a genuine, present, and sufficiently serious threat. The fact that the OIS's report displays a mixed picture isn't determinative.
sorry, maybe it's just me. isn't this all premised upon, as you say, paragraph 36,
Yes.
that there's an error of law, and what you're dealing with here is whether, even if there's an error of law, it's unnecessary to set aside the decision. And you're saying, no, there was an error of law and it wasn't inevitable
Yes.
that you'd reach the same conclusion.
Yes.
I understand that. So you say at that stage the test is inevitability.
Yes. Yes.
You say it can't get close to it because it's clear that a tribunal addressing the factors could have reached a different conclusion. If you're wrong on the first point
Yes.
about error of law,
Yes.
are you separately saying that the I'm slightly difficult. I find it difficult to understand why we're or what your argument is about the way in which the power to remake doesn't arrive.
No, on my there is. Well, the way I put the second ground is that the First Tier Tribunal's decision was wrong in law.
Yeah.
And it wasn't open to, and it was materially wrong in law. Failure to have regard to relevant matters is a material error.
Yes.
And it was not open to the Upper Tribunal to uphold that decision.
Because you say it wasn't inevitable.
It wasn't inevitable.
Right.
Yes.
So what they should have done what?
They should have set aside the First Tier Tribunal's decision.
Yes. And
If they had set aside the First Tier Tribunal's decision, then they could have remade the decision, or they could have remitted the appeal for a fresh hearing. In remaking the decision, they were obliged to engage with the reasons given in the decision letter, with Schedule 1 considerations, and so on.
but why isn't that what they did? I mean, the last pages of the judgment are them engaging with that, aren't they?
No. Well, what they are saying, in my respect, submission is that, well, we are sort of conducting a review of the facts of this case,
Yes.
and if we were considering this question, we would have decided that there were no imperative grounds.
We're not. We're not doing that.
Yes.
What you're saying? So
Yes. Can I perhaps illustrate my point by giving this example as to your role in this appeal? Now, the powers of this court under Section 14 of the 2007 Act essentially reflect that the powers of the Upper Tribunal. The statutory scheme is simple. So the question for you, my lady, my lords, is whether there is an error of law in the decision made by the First Tier Tribunal. You will decide whether there is an error of law, and you will then decide whether the error is material to the outcome, whether the decision should be set aside. If you decide that there is an error of law and you set aside the Upper Tribunal's decision, you then have two options. Option A is to remit the appeal for a fresh hearing, and option B is to proceed to remake the decision as the Upper Tribunal or the First Tier Tribunal. And if you're remaking the decision, then you'll have to engage with Schedule 1 considerations. You'll have to engage with the reasons given in the decision letter, and you then make a primary decision. This is not what the Upper Tribunal has done. This isn't a case where the conclusion at 56 by the Upper Tribunal is that the appeal, even if the FTT ought to have made its own findings as to the existence of imperative grounds, it would have been bound to have concluded that no such grounds exist, and I seek to impugn that conclusion. If that conclusion is wrong, then in my submission the appeal succeeds.
And we remit.
You remit, yes. So that there is a proper decision as to whether imperative grounds exist.
I mean, there's a problem, the same problem with the Upper Tribunal's decision as there is with the FTT's decision, which is that both tribunals ignored the prison sentence in 2008.
Yes. So if you
If you look at the summary of the facts for the Upper Tribunal, they just
Yes.
don't refer to it.
Yes. So if you wish to see why I sort of criticize the substance of this decision, that is paragraphs. So the points that I've made in my skeleton are
Yes.
paragraphs 39 and 42.
Yes.
It will assist you on the substance as well as they would in relation to the question of inevitability. So the failure, as Milady pointed out, there is a sentence: the failure to have proper regard to two warning letters, the earlier deportation action, the warning that the First Tier Tribunal gave in the
Yes.
earlier proceedings, failure to engage with paragraph 3 of Schedule 1.
I mean, they do refer to Schedule 1, as Milady pointed out.
Yes, paragraph 55, that they take into account factors set out in Regulation 27.5 and Schedule 1. But that really is what they've said. So they were dealing with it in a sort of summary format, which isn't in my submission adequate or permissible.
Thank you.
Now, just one last thing that I must deal with, that is Miller and Friend's skeleton argument as to this particular ground. Can I just show you that document and give you very brief submissions as to that? So if you go to page 42 of the court bundle,
Yes.
you'll see.
Okay.
Yeah, page 42. You see the submissions that Miller and Friend has made as to ground 2. Miller and Friend says that, well, this ground is a mere disagreement. It's not. Miller and Friend cites Velopi versus Velopi, that well, due deference should be given, but
Yes.
that does not apply here
It
because
doesn't arise unless and until the Upper Tribunal is remaking the decision
precisely
and
you-
acknowledging that it's remaking the decision.
Yes. And you cannot, in my respect submission, give due deference to the First Tier Tribunal's decision when its decision on imperative grounds is expressed in one sentence. I find that there are no imperative grounds. So these principles do not apply. So this is paragraphs 51.
And indeed, the terms in which the Upper Tribunal refused permission to appeal on ground 2 are in a sense an indication that they were making a factual and evaluative assessment.
Yes.
Because they say, well, this is just disagreeing with our evaluative assessment.
Yes. But there wasn't. That is really the point. Yeah. So that deals with the first point that Melanchthon makes. The second point that Melanchthon makes is at page 45. He says that well, Schedule 1 just does not apply to imperative grounds at all. Well, that with respect is just wrong in law. There's absolutely no doubt that Schedule 1 applies. This is paragraph 60 and 61 of my Lenin Friend skeleton argument. There's absolutely no doubt that Schedule 1 applies to all three tiers. Serious grounds, to imperative grounds, and to all other cases. So 61 Lenin Friend says that the language of Schedule 1 makes it plain that it only applies to middle tier cases, not to imperative grounds. That cannot be right. So that submission is wrong. The remaining submissions are submissions on merits. But of course, in my submission, this court should not do what the Upper Tribunal did. take a view as to the merits of the case. I mean, the task is whether there is an error of law. If there is, then the next question then arises. So in short, if you are persuaded that ground 1 should succeed, you will allow the appeal, you will remit the appeal to the First Tier Tribunal to consider whether there are serious grounds justifying deportation. And in those circumstances, ground 2 would not arise. If you dismiss ground 1, and if ground 2 succeeds, then you will allow the appeal and you will remit the appeal to the First Tier Tribunal to consider whether there are imperative grounds. So I invite you to allow the appeal on ground 1, but if I'm wrong on ground 1, then ground 2 is the alternative ground. My sincere apologies.
We took you at a much slower pace than you anticipated through the material. Thank you very much.
It's my fault for asking you lots of questions. So I
Yeah,
apologise
we
for that.
all ask questions.
Definitely my fault.
We're all apologising to you, Mr. Malik. Thank you very much. Thank you. Yes, now, Mr. Kareem.
My lord,
10 minutes before lunch.
my lady, yes, I'm grateful. Clearly, we've strayed beyond the original time estimates. It's an uncommon.
Well, it's whoever's fault it is, whether it's Mr. Malik or us, it's not yours. So far.
So clearly, we won't be able to finish before the lunch.
No, of course not. Of course not.
Um,
However strong your arguments are, we're going to need more than 9 minutes.
May I, with the court's permission, just begin by headlining or summarising Mr. Borges' position,
That would be very helpful. Thank
and then
you.
I'll delve, as it were, into the substantive submissions. In terms of the first ground, the interpretation ground, our position is that the Secretary of State's interpretation is simply incorrect.
Yes.
It's contrary to the clear language of the directive and the regulation. The Secretary of State is unable to point to any authorities to support her contention. I recognise it cuts both ways, but given we have 2 decisions from tribunals below, given it's a Secretary of State who's asserting a contrary interpretation, we say that there is some burden on her to provide some type of support or corroboration or substantiation to the point she's making, other than to simply say, well, actually, this is what it means by inserting language which clearly does not exist within the directive and regulation. And in my submission, the First Tier Tribunal and the Upper Tribunal were correct to reject the interpretation advanced now and prior to now by the Secretary of State. And it is, in my submission, the case that the interpretation adopted by the First Tier and more specifically the Upper Tribunal is the correct one. Turning then to the second aspect of the Secretary of State's case, the imperative grounds, assessment, analysis, we can call it whatever we like. I can't stress enough the fact that this is, in my submission, the Secretary of State's 6th bite of the cherry. Before the First Tier Tribunal, in her refusal decision, in her review, and orally before the First Tier Tribunal, she did not advance any imperative grounds. That's something that I emphasize significantly. I'll come back to that in a moment.
Well, what she's going to say, what she says is, or Mr. Malik says on her behalf, is she didn't have to because of ground 1.
Yeah, well, this is where the difficulty is with the Secretary of State's case, because when the writing was on the wall, and I'll take you to the documents, she did have to. She cannot simply expect a tribunal to second guess. We all respect the First Tier and Upper Tribunals. They are specialist tribunals. My lord, my lady, one thing they're not are clairvoyants. They cannot second guess what, if any, imperative grounds exist, particularly given the fact that there is no specific definition of what an imperative ground is. But I'll come to that in a moment. So I say that the criticism leveled by the Secretary of State against the First Tier Tribunal is remarkable. And there are other submissions to be made in respect of that point as well. And as I said, I'll come to that in due course. What the Secretary of State is now trying to do, when we look at what she argued before the Upper Tribunal, is trying to now re-argue the entire case, saying, well, imperative grounds do exist for X, Y, and Z reasons. I'll take you back to the Upper
Only if she fails on round 1.
Round 1, yes. I'll take you back to the Upper Tribunal's determination, where Ms. Everett, a very experienced senior presenting officer, put ground two on the basis that, well, if you're not with us on ground one, you can remake it. All we're relying on
Well,
is the
you'll have
OAC.
heard me refer to my puzzlement about what the Upper Tribunal said about the submissions.
Yes,
You were there, so
precisely.
hopefully you can enlighten us.
Yes.
when
So
we get
that
there.
is the way that it was put forward, essentially without any real vigor, without demonstrating or emphasizing, well, these are the imperative grounds. There was a mere reliance on the Oasis report.
Yeah.
And in my submission, in those circumstances, given what occurred before the First Tier and the Upper Tribunal, it's very difficult to criticize either of them in circumstances where the Secretary of State hasn't put forward any imperative grounds. And again, I'll deal with that in due course, but this is the highest level of protection, and it's there for a reason. The words imperative grounds are there for a reason. It's not something which can be taken lightly and left, for example, for a tribunal judge to second guess as to how it should be applied to a particular case. In terms of the submission that the claim is academic, I of course rely on my supplementary skeleton argument. But in addition to that, we say that the Secretary of State's analysis as to why it's not academic is erroneous for a number of reasons. Firstly, the Secretary of State relies on Schedule 1 as well as Regulation 27, subsection 5, which requires the tribunal, essentially as the primary decision maker, to assess whether the person poses a genuine and present threat and to engage with proportionality. So if a tribunal is seized of that task, and if, as Mr. Malik says, that the tribunal, even in the absence of any imperative ground put forward, has to for itself undertake the assessment, including proportionality, it's difficult to conceive how the fact that the 10-year period has now been met on the Secretary of State's consent, on the Secretary of State's construction, could never be a relevant point. It would almost inevitably lead to the conclusion that even on that analysis, the applicant, as he was before the First Tier Tribunal, has completed the 10-year period. But there are other arguments to be made by reference to the regulations, and I'll take you to that in due course.
Okay.
If I can then perhaps, in the 5 minutes remaining, begin by taking the court to the authorities bond bill.
Yes.
And
What can you do helpful in 5 minutes? Do you want to start with the directive?
if I may, my lord, yes.
Yeah. We won't take as long because
We've been through much of it. So
we've
I'll
been
just-
through much of it.
yes.
So even to those of us who's not, very familiar territory, will be familiar with
I'm grateful.
10:30. Yes.
If I can take you firstly, my lady, my lords, to recital 17, that's on page 4.
Yes. Well, we alighted on 17, didn't
Yes. We have, and it's important to emphasize that the directive recognizes that union citizens who have chosen to settle long term would strengthen the feeling of union citizenship, and this is a key element in promoting social cohesion. So the fact that someone is a union citizen is not something that is simply there. It is relevant to this promotion of social cohesion, essentially to a sense of belonging, etc.
Yeah.
And in my
And you would say that attaches to a union citizen whenever they become a union citizen. So you say that recital arguably, you would say it does, but arguably leans in favour of your interpretation.
Yes, and my lords, when we look at the directive and the regulations, what is clear, at least in my respectful submission, is that there are 3 classes of people that these provisions seek to protect. You have the union citizen, also referred to as the EEA national.
Yes.
You have their family members.
Yeah.
And then you have other family members, also referred to as extended family members.
Yeah.
Now, what the Secretary of State is trying to argue in this case is that somehow the applicant falls between category 1 and 2. So he's not a union citizen for the purposes of Regulation 27, but he is neither a EA national. And what my learned friend in his opening submissions highlighted is that this applicant, Mr. Borges, the respondent in these proceedings, is a Portuguese national, therefore a union citizen, and that is not by accident. And that is reflected in the directive and in the regulation that greater protection is to be afforded to union citizens, as it were. And one thing I should just say at the outset is that if the Secretary of State's construction is correct, what it would create, in my respectful submission, are two classes of union citizens. One class who've been union citizens throughout the 10-year period, who somehow enjoy a stronger protection than the second class who've been union citizens for part of that period, who, for some unknown reason, are designed to have less protection. And that simply could not have been the intention of any of the drafters of any of these provisions, because they only categorize everything into three. There's no distinction in the union citizens between those who have been partly union citizens and partly non-union citizens. And therefore, I say that that construction simply does not work.
Well, obviously, Mr. Malik will focus on lots of things, but particularly on the wording of Article 27.
Yes.
We'll come on to that in due course.
We will do, my lord. Yes. Then moving on to recital 24.
Yeah.
And again, I'm not going to read the entire thing out. Page 5 of the authorities bundle. Accordingly, the greater the degree of integration of union citizens and the family members in the host member state, the greater the degree of protection. Only in exceptional circumstances where there are imperative grounds should an expulsion measure be taken against union citizens who have resided for many years in the territory. There's no reference there, of course, to the 10-year period, but for many years. So there is again a recognition that a person who is a union citizen who's resided for many years deserves a greater degree of protection. And again, that's the foundation or the backdrop to which we have to then go on to consider other provisions. Now, there is no dispute that Mr. Borges came to the UK in 2002 as a family member. And in fact, he obtained permanent residence in 2007, so well before any offending began. He was already a permanent resident by then. And therefore, the relevance of whether or not he has obtained permanent residence as an EEA national, a union citizen, is perhaps less relevant, because even well before any criminality began, back in 2007, he'd already obtained permanent residence. And I'll come back to the relevance of that in due course.
So you may have mentioned it, but I can't remember whether we looked at recital 3 or whether we didn't. I didn't make a note of it, but it starts out, union citizenship should be the fundamental status of nationals of the member states when they exercise their right of free movement and residence. I think what you're saying is that when you're testing somebody's right of residence or anything relating to it, it's the status of union citizenship which is important.
Precisely. And the status of that union citizenship, as at the date of the deportation decision, is paramount in this case.
Well, it's use the word in 3, when they exercise their right of residence. Is that right? Or is that?
Yes, so once...
Right, is that a convenient place to stop now, Mr. Karim? Thank you very much. We'll resume at 2 o'clock. Thank you.